The issuance of a warrant. After a complaint is laid before him, so you've got to have a complaint first. Somewhere, somebody had to write up a complaint, which may be in the form of the Idaho Uniform Citation, in the case of a misdemeanor, that's a traffic ticket. A magistrate may, it doesn't say he shall issue a warrant, it says he may issue a warrant for the arrest of the defendant only after making a determination that there's probable cause. Let me tell you, in this state, I don't think there's more than 3 or 4 magistrates that even understand the word probable cause. I'm not saying all of them, I'm just saying that these people routinely issue warrants when there is nothing in the way of probable cause or even reasonable suspicion under the Terry rule. I mean reasonable suspicion to believe that anything is amiss. These policemen in this state and these prosecutors or prosecuting attorneys just have carte blanche. They've got a credit card. When they walk in with your name on it, that magistrate's just going to sign it. That's the end of that argument. They don't even need reasonable suspicion or probable cause, but yet the rule calls for probable cause. Why don't you motion up and demand to know what the probable cause was when the complaint was issued and when the warrant was issued? To believe that an offense has been committed and that the defendant committed it. He's got to have probable cause that you're the one that did it. That requires some kind of evidence. And it requires an affidavit in support of the complaint. So somebody, when he wrote up the complaint, had to swear on an affidavit that he, with his eyeballs, saw you do this. And that he's the complaining witness. Make him do that. The policeman issues you a traffic citation. The prosecutor takes over the case. File a motion with the court and demand that you have 2 things. 1, a formal complaint. And 2, an affidavit in support of the complaint. Make them dot their I's and make them cross their T's. I know it sounds like a little extra work, and that's right, it is. But if you're not willing to do the paperwork, then get out of this game because you're going to get hurt. They're going to put you in jail, and they're going to beat you up, and they're going to do bad, wicked, terrible, and awful things to you. And you'll never be able to win because, remember, 50% of your case is in paperwork. And so if 50% of your case is in the paper, and 25% of your case is in procedure, and the procedure is embodied in the rules, and 25% of your case is in the presentation, what you see in the courtroom is this. The citizen goes in, he can't read or write, and he files no motions, no affidavit of defense. He doesn't put anything in the court in his own defense, in the way of written paper. And then he goes in there, he doesn't know his right foot from his left, and he can't talk. He can't walk and talk at the same time, so he can't present his case, and he hasn't read the rules, much less done any study or any work on trying to know and understand the rules of the game, and his chances of winning are exactly 0, aren't they? And isn't that exactly what you've always observed? Every time you've gone into court, haven't you lost? All right, so going on then. The issuance of the summons, then, this is Rule B, 4B, after a complaint is filed with a court, which may be in the form of the Idaho Uniform Citation for misdemeanor, the magistrate or the clerk of the court, so you got 2 people, magistrate or the clerk of the court may issue a summons. There's a difference between a summons and a warrant for your arrest, isn't there? Requiring the defendant to appear before the court at a time certain without first making a determination of whether there is such probable cause. Well, let me tell you what you've just read there. If the policeman goes in and says, Judge, I want you to issue a warrant, and the judge says, well, what's your probable cause? Well, I don't know. I just think this guy needs to be brought in. If there's no probable cause, you cannot be arrested. It says so right here in the rules. They have to issue a summons to summons you before the magistrate. Why don't you challenge them on that? What probable cause did you have, Judge, when you issued the warrant? Why didn't you issue a summons? Why didn't you follow Rule 4.B or 4B? If there was probable cause, then what was the probable cause? Make him articulate that. You know, the Supreme Court says that you have to have reasonable, articulable suspicion as a very bare minimum. Reasonable, articulable suspicion. What can you articulate? What facts can you recite that would indicate that I've done this? All right? Nobody does that, do they? Do citizens do that? No. They've never read the rules. All right? So There's another motion for you to motion up. Issuing the warrant or the summons. Preference for a summons. Your Honor, why did you issue a warrant instead of a summons? What reason did you have to believe that I wouldn't follow the dictates of the summons? You know, after you've been arrested 3 or 4 times, you ought to bring that up, because once you've brought that up, it shows bad faith on their part. You remember, in equity, you've both got to come to court with clean hands. You want to come to court with clean hands. Always make your appearances. Do not fail to make your appearances, because if you do, then the judge is always going to issue a warrant, and you lose that argument later on in the appeals process, because later on you're going to say, well, they should have issued a summons. Why? You didn't appear on thus and such a date, and you didn't make that other appearance over here. Why would he suppose that you would honor a summons? Whereas in my case, I've never made a failure to appear, and so therefore, for that reason, it's difficult for them to issue a warrant for my arrest anymore. So if the magistrate finds such probable cause for a complaint laid before him, in determining whether a warrant or summons should issue, the magistrate shall give preference to the issuance of a summons. They don't do that in Idaho. I don't think that there's a magistrate in the state that issues a summons in preference to a warrant. They'll always try to punish the citizen by issuing the warrant and having him arrested, typically on a Friday afternoon, so that they can hold you until Monday and punish you for 3 days in jail. Now, you're going to have to be prepared to suffer that inconvenience, and never let them know that what they're doing to you is punishment. When you go to jail, you need to be applying the jailhouse scene, gathering evidence all the time. Names, evidence, facts for the Title 42 suit for deprivation of your rights. Wherever you are, when you start getting some lawsuits put into your federal district court for deprivations of rights and suing a judge occasionally, it may be necessary to put a judge on the hot seat once in a while, but try to avoid that if you can. Because remember, we're appealing to our judicial branch of government. And I don't like to send the wrong signals to the judges. We want the judges to put their neutral hat on and take their prosecutorial hats off. That's what your goal is. In making such a determination as to whether a warrant or a summons shall issue, the magistrate shall consider the following factors. And so, on bail, they have to consider these factors pursuant to Rule 46. Now I want you to flip over to Rule 46, and I'm going to show you this thing called being released OR. Rule 46 is on page 470. There's another lesson for you to pick out here. They'll try to get money out of you. Here's your goal. Never give them money. That's what they want. Deprive them of the money. Federal Reserve notes. When they arrest you, they'll say, well, if you'll post $175 bail, you can go. I don't want to post bail. It grants jurisdiction. I demand to be released OR. And why, officer, didn't you issue a summons? Why did you arrest me and take me to jail? In other words, be asking questions while you're in the jail. They have to bring you out in 24 hours anyway. Why give them a $170 loan for 6 months or a year or 2 years while you have to fight and scratch to get the money back? Don't give them the money. Just stay in jail. The next morning you'll come out. Then invoke your right to be released under Rule 46, where it says bail or release on his own recognizance. Right to bail or release before conviction. You're not even convicted. They've just arrested you and thrown you in jail. A person arrested for an offense not punishable by death shall be admitted to bail or may be released upon his own recognizance at any time before sentencing. A person arrested for an offense punishable by death may be admitted to bail in the exercise of discretion by any magistrate or district court authorized by law to set bail. The determination of whether a person should be released upon his own recognizance or admitted to bail, and the determination of the amount and the conditions of bail, if any, can be made after considering any of the following factors. And so here are the factors. You need to learn and understand those factors. Well, let me show you how I do this. Remember, at the bail lesson? Well, Your Honor, I qualify to be released OR, and therefore I move at this time that the court release me on my own recognizance because I am employed, I am a resident, I am married, I do have children, my children are in school, and I've always made my court appearances. There's no reason for this court to believe that I will not make my appearances, and then put the burden then on the prosecutor to show why bail should be set. Now, there's another rule that you have to follow. If you routinely pay bail, you then routinely grant jurisdiction in personam to the court. Stop doing that. Don't ever give them jurisdiction. You may want that as an appealable issue at some point in time. All right? In the state of Idaho, it's under Title 19, and I forget the exact statute, but there is bail. All right? The rules to bail run something like this. Let's say that you're arrested on a felony, and they'll start charging you with felonies as soon as you start demanding your rights, and especially you people that live up in the state of Washington. Let me tell you, that state of Washington is a police state on the order of Nazi Germany. You have to have papers when you cross the border, and you better have your papers in order, Mr. Citizen, let me tell you. Your papers had better be there, and they better be in order, or you will go to jail when you cross the border from Coeur d'Alene to Spokane, Washington. And that's a fact. And if you think that's some kind of a wild joke, I got news for you. One of our students just got out of jail last week up there in Spokane because he didn't have his papers in order. All right, going on then. Under this Title 19, you should have friends who have a piece of property or some property within your county that will qualify as bail. You can have an arrangement or an agreement. Maybe one or two people of your close association, not group or association or you know, whatever you want to call it, the Ku Klux Klan, you know, they always want to put you into this group. And I mean, some friend should have a license for bail bond or a status of a bail bondsman, or you need to go talk to a bail bondsman and say, okay, we want to keep money away from our government. We want you to act as the bail bondsman for this or that reason. And remember now, when you're doing this bail bond thing, you're going to lose 10 or 15%. And they'll keep arresting you, and they'll keep having you post this bail because, you see, that's your punishment. What you need to do is to take every last dollar away from them. I'll spend a month in jail before I'll give them 35 cents, even in phony Federal Reserve money. That's how serious I am. And my close associates do the same thing, because you can always get out on a writ of habeas corpus, and you can get out OR, and you can get out after you've provided the bond. Now, there's, in our state, in Idaho, and it'll be the same wherever you are, you'll have to look it up, you post bond, do not pay bail. That way, and I have a friend that just posted a $2,500 bond for me, and that bond is sitting there, and all it is a lien against this particular piece of property, and as long as I make all the appearances, then the bond will not be forfeited. So he's acting in the capacity of a bail bondsman. It doesn't cost me the 10 or 15% that it would cost to pay a bail bondsman, and I'm out of jail, right? And we've done the key objective. We have denied them an interest-free loan. And we're out working on our case, and we're putting our paper, and we're putting our rights, and we're putting our demands before our courts. And that's where they belong, in front of the courts. Not the policemen holding curbstone courts setting bail, which they do in our county. You can go out here to the county jail, and they're setting bails out there. If you don't think that's some phony baloney. But you can't solve every problem overnight, so only settle in on one or two problems, one or two issues at a time. And don't allow them now to arrest you 5 times so that you've got 5 cases going. If you're a novice at this, you should never do more than 1 or 2 cases at a time. If necessary, swallow your pride and go get a driver's license or registration or whatever it is you have to do while you're arguing this case through the courts. And then come back. When you're experienced, you can do 10 cases at a time. I did a little research the other day, and right at this moment in time, I'm doing 13 separate cases. I bet you there's some lawyers in town that wish they had 13 cases to do. Business in this town has been pretty poor lately. Now, under this Rule 4, then, the judge is supposed to look at some of these very same indicia that would qualify you for release OR. you want to file a motion and demand that he tell you whether or not he did that. Because did you consider the residence of the defendant? Did you consider the employment? Did you consider the family relationships? And in the motion hearing, you ask him these embarrassing questions. Why did you have me arrested? Why did you issue a warrant instead of a summons, which says under Rule 4 that you're to give preference to the summons? And about the second or third time this judge does this to you, what you're showing is a malicious bent on the part of this magistrate to arrest you instead of giving preference to this summons. Then you need to start writing letters to the administrative law judge of that particular judicial district. Then you need to take a look at Rule 10. It's not Rule 10, it's Title 10-1201 and 1202, which is called a declaratory judgment. A declaratory judgment is a civil action that you take into the district court to get a restraining order against these judges and against prosecutors that are maliciously harassing you and prosecuting you. But before you can do that, you've got to have 3 or 4 cases of this malicious harassment. And if you keep paying bail, then you're not suffering a loss. So let them throw you in jail. Let them keep you in there for a week at a time so you can establish a loss so that you've got something to sue for. All right, now, I'm not going to read each and every one of these. I want to just give you some opposites here so that I'll kind of tickle your curiosity as we go through. Remember, there's 54 rules here. Flip over to Rule 6, and I'll show you that we still have a rule in the state of Idaho commanding that we have the grand jury. We haven't had a grand jury. I've heard it rumored in this state for 18 years. All right? We're going to start having our grand juries because if you don't have a grand jury, then in a felony, and I'm not talking about misdemeanors, except in Idaho, any case of any grade has to be brought to a grand jury. Somebody go get me an Idaho Constitution so I can show in this lesson how this comes down. Let's see, Rule 6. Let's just read through here. The grand jury, summoning a grand jury. A district judge may order one or more grand juries to be summoned at such times as the public interest requires. I contend that the public interest is always required, or that a grand jury is always required in my case because I'm always bringing up subjects that have grand jury implications which are rights issues. If you're just talking about the bank robber that stuck up the bank, it may not be necessary because he's not going to complain about the information that's being brought against him. But I'm going to be complaining about it each and every time, especially when they're charging me for stealing traffic tickets, for crying out loud. Even the thought of it's so absurd that it ought to make anybody who's got any intelligence at all laugh at the absurdity of charging a man with a felony. Even if he was guilty of stealing the traffic tickets, would we want to spend $3,000 and put this guy in the penitentiary for 28 years and spend about $1 million on his incarceration? All right, at such times as the public interest requires, the grand jury shall consist of not less than 16 members, a quorum of which shall consist of at least 12 members, and the district judge shall direct a sufficient number of legally qualified persons to be summoned to meet this requirement. Well, as you read through here, it tells you how the grand jury is put together, and it's a pretty long rule, and there's a lot in here that needs to be said and talked about. And I don't know about your particular state, but pull out your state constitution here. This is Idaho, Article 1, Section 8. Okay, zero in on this so everyone can follow along. This is called the Idaho State Constitution. Now, I know some of you people are in Texas or Illinois or somewhere else. In your Constitution, there'll probably be something in there about grand juries. And find out how your state works. But in Idaho, and this is what we're trying to learn, is how the system works, so let's just take Idaho as an example. Prosecutions only by indictment or information. So there's 2 subjects here. Indictments, underline indictment, or information. No. First word, no. Negative. No person shall be held to answer for any felony. Okay, you've been charged with a felony? Why don't you underline felony? Or, that's not and, that's or, criminal offense of any grade. So I'm going to underline criminal offense of any grade unless on presentment of indictment of a grand jury. All right, so I'm going to underline, unless on presentment of indictment of a grand jury, now you get or, on information of the public prosecutor, public prosecutor. That's an interesting word. Do we have public prosecutors in Idaho? Give you $100 if you can show me one and tell me his name. Write in, let me know where the public prosecutor is. We'd like to know. We've been looking for some 5 years for a public prosecutor in Idaho. Now the judge is going to say, well, he's sitting right there to your left, Mr. Gordon. That's Mr. Jones of the Ada County Prosecutor's Office. Prosecutor's Office? I thought he was a prosecuting attorney. Now do you see how important these words are? Look up the word prosecuting attorney. Go get me a Black's Law Dictionary, somebody. Prosecuting attorney and public prosecutor, and they're two totally separate kinds of cats. Yeah, they're both cats, all right, but one of them is a lion and the other one's a tiger. All right, let's go on. And notice here that in the state of Idaho, an offense of any grade, the grand jury has to be called, after a commitment by a magistrate except in cases of impeachment, in cases cognizable by probate courts, we don't have any of those anymore, or by justices of the peace, we don't have those. Well, I shouldn't say we don't have probate courts, yeah we do. We don't have these justices of the peace, they've been changed to magistrates here in this state. And in cases arising in the militia when in actual service in time of war or public danger. Well, it's obvious that that doesn't apply. I'm not in the Army, I'm not in the militia. Provided that a grand jury may be summoned upon the order of the district court, and remember we saw that in Rule 6, in the manner provided by law, and there are statutes on that subject, and provided further that after a charge has been ignored by a grand jury, no person shall be held to answer, or for trial therefore, under or upon information of the public prosecutor. Now remember that this subject matter of the public prosecutor is an extremely important issue when we're talking about rights, because a public prosecutor will prosecute you in the name of the people of the state of Idaho, and you have to go before a grand jury. But in cases where a public prosecutor is prosecuting, it's done in the name of the state of Idaho. And in the name of the state of Idaho, that's correct. There's no problem with that. The state of Idaho is a body politic. It's a body corporate. And it has corporate interests. And when any of its corporate interests are involved, it has the right to sue and be sued, just like any other municipal corporation. Okay, turn in Blacks here to page 1099, and let's take a look at the rules of the game by definition. On page 1099 of Black's Fifth, we have the name of this is the prosecuting attorney, the name of the public officer who is appointed or elected in each judicial district, circuit, or county to conduct criminal prosecutions on behalf of the state or the people. Okay? So that's what he's for, but he's not a prosecuting attorney. I mean, he's not a public prosecutor. He is a prosecuting attorney. And going on, it says federal prosecutors represent the United States in prosecuting federal crimes. A locally elected officer who represents the state in securing indictments and information and in prosecuting criminal cases, also called the district attorney or the state's attorney. Bottom of the page, let's look at what a prosecutor is. One who prosecutes another for a crime in the name of the government. And there you are. Here's your prosecutor prosecuting crime in the name of the government. That's the state of Idaho is the party of interest. But what happened to the people of the state of Idaho as a party of interest? That's why you don't have a grand jury, because these cases are prosecuted in the state of Idaho in the name of the state of Idaho by a prosecuting attorney who's elected by the people, who is not appointed by the government. The governor, rather. Not government, but appointed by the governor. And so since he's not appointed by the governor, reading on here, It is one who instigates a prosecution by making affidavit. See why you demand the affidavit in support of the complaint. Charging a named person with the commission of a penal offense. Underline the word penal and look it up. That's the penalty clause of a contract. Now, how can the state of Idaho prosecute me criminally for doing anything when there's no contract? Where's the corporate contract? Am I a corporation, chartered, association, trade, banking organization? No, I'm a natural person. You see what they're doing is prosecuting natural persons. Remember Hale versus Hinkle? There's a clear distinction between the natural person, the individual who has constitutional rights, and the corporation. See, a corporation has no rights, and it cannot resist the suit of the state. And so what they've done, they have just encompassed all of us, right along with all of the corporate interests in the state, and they just treat us like they do Boise Cascade or any other entity that does not have rights. And so they just plainly don't recognize our rights. Going on. Then it's the prosecution and the imposition of a penal offense or a penal statute, a penal clause of a contract, and they're called penal statutes, on which a warrant is issued for the indictment or information is based. And it's one who instigates the prosecution upon which an accused is arrested or who prefers an accusation against the party whom he suspects to be guilty. Okay, now let's take a look at Bouvier. In 1870, you don't even find prosecuting attorneys. You've got public prosecutors. And you'll find that. Take this book out now. This is Bouvier's 1870. And this word prosecutor. Let's take a look under, it's on page 389 of P. I'm looking at prosecution first, and that's in the first column, where it says, what is a prosecution? The means adopted to bring a supposed offender to justice and punishment by due course or due process of law. Prosecutions are carried on in the name of the government and have for their principal object and security the happiness of the people in general. All right? Okay, the next word down then, prosecutor. He who prosecutes another for a crime in the name of the government. Now look at the word public prosecutor comes next. The public prosecutor is an officer appointed by the government to prosecute all offenses. He is the Attorney General or his deputy. A private prosecutor is one who prefers an accusation against a party whom he suspects to be guilty. These prosecuting attorneys are, in fact, private prosecutors working for the state of Idaho. Nothing more, nothing less. And they're enforcing the penal clause or the penal portion of the contractual agreement. And what they're doing is enforcing penalties of contractual nature under the rules or in the form of criminal actions. And they're doing it to people that they haven't got any capacity or jurisdiction to do it to. And they do it by information instead of by an information to the grand jury. The information is to be given to the grand jury and let the grand jury then ask the questions and determine whether or not this person should be prosecuted. You see why in the state of Idaho they hate this name grand jury? It takes power away from these little petty dictators in the prosecutor's office. They then lose the power to determine or decide who they're going to prosecute. Now you begin to see why it is that our Republican government can't function. We are, in fact, practicing democracy. The way we get our redress of grievance isn't through rules of procedure and criminal rules where citizens walk into the courtroom and demand rights, demand to be heard on a one-to-one basis. What we're witnessing here then is mobs of people. And this is almost always the case, and this is the way you've always been taught and trained. You have to join this union so that the union can go to the legislature and lobby and get the law changed. So in effect what they're saying is that all the slaves down here don't object to the taxes. They're not claiming any rights. They're just claiming, they're just bellyaching, they're just objecting to the master being too severe. What I'm suggesting is that we who are free, or who want to be free, tell the legislature to go exercise its sovereignty over that class of persons that it has jurisdiction over. That is, the unions and trade associations and trusts and foundations and corporations and other trade, commerce, business, and industry. And when you have a beef with a citizen, that you then call the grand jury and let the citizens decide whether or not they want to prosecute one of their own. This case called Yick Wool versus Hopkins Sheriff is a classic in the subject matter of sovereignty. And this case called Macon versus U.S. is another classic when it talks about informations versus grand jury indictments. In the state of Idaho, let's take a look at what our governor does on page 13. We're in the executive branch of government. And this is Article 4, the executive department. Take a look over here with me on page 13, Article 4, Section 5. And I'll show you what I'm saying. The supreme executive power vested in the governor. The supreme executive power of the state is vested in the governor, who shall see that the laws are faithfully executed. The governor of the state of Idaho does not execute the laws of the state of Idaho. And if he wanted to, he couldn't do it. He doesn't have any ministers. He doesn't have any appointed public prosecutors that he can call into his office and say, I want you to go prosecute this law. I want you to go put this law into effect. That's done by our county prosecuting attorneys, who are simply the private lawyers of the state of Idaho, which is simply a corporation which is enforcing its contractual agreements with all of its proper subjects, and then expanding its proper authority over its proper subjects to include subjects who are free and natural individuals that they do not have the proper authority to prosecute. When you're being prosecuted, you want to bring up that subject of the information, the prosecuting attorney, the public prosecutor, the executive power of the governor, not government, but governor. Take a look at Article 2, Article 5, and Article 18, and find out what kind of animals we're dealing with here. We're dealing with cats, all right, but these prosecuting attorneys are a cat with the wrong kinds of stripes on them. Now, you'll see that this grand jury is an example then, and in this state we have grand juries by, I believe this is Idaho Code 193501. Now, don't quote me on that exactly. Make sure you check this out. But I believe that, or no, it's 191101. Excuse me, I just jogged my memory. That talks about grand juries. So by statute, you have to be indicted by a grand jury. By Rule 6, you have to be indicted by a grand jury. By the terms of the Fifth Amendment to the Federal Constitution, you have to have a grand jury. And by the terms of our state constitution, a parking ticket would have to be brought to the grand jury if they're going to put you in jail. And then, to add insult to injury, the Supreme Court of the United States in these two key cases, they're called Ex parte Wilson, Ex parte Wilson, which I think was 114 U.S. 422, and this case called Macon versus U.S., which was 117, which is 1885, and I believe it was on page 348. All right? There's two cases where the Supreme Court of the United States said that if you've got an infamous crime, by definition under our Fifth Amendment to our federal Constitution, you've got to be indicted by a grand jury. Now, if we haven't had grand jury indictments in the state of Idaho for 18 years, would you say then that our elected and appointed officials and our judicial officers are obeying the laws and the rules that we, the people, set down in our Constitution, that the Supreme Court of the state set down in the rules of procedure, and our legislature set down in Title 19, Section 1101? Here you've got violations of law by the legislature, the governor, the judges. And you know why they don't have to obey the law? Because you never walked into the courtroom and never said, here's the rules, troops. Let's obey the law for a change. Let's be real different, Judge. Let's us obey the law. Let's ignore what the people are doing in the next room. Have you ever heard of anybody do such a crazy thing? It's like walking into a courtroom and say, hold it, the Bible says not to swear, so I'm not going to do that. And I know that's insane, and I know that when you walk into a courtroom, I did this last year, I was charged with a felony, tearing up my jail suit or something. Somebody threw some rags underneath my bed and said that I tore down a jail, and so I walked in the courtroom and said, hold it, where's the grand jury? And I kind of look around like, where is the grand jury? I don't understand what's happening here. I got my state constitution out, and this judge just couldn't believe what he was hearing. And so he started off with a bunch of gobbledygook, and let's start over here at Article 1, Section 8. I'll show you how this judge behaved when I brought up the subject. Here's your Idaho State Constitution, okay? Here's the rules. Now, in constitutions, you know, right away someone's going to say, well, what is the superior law? Is it the rules of procedure or the Constitution of the state of Idaho? Okay, the answer comes from a case called Marbury versus Madison. If you want to know what the superior law is, always go back to Marbury versus Madison, 1803. And it tells you plainly the Supreme Court of the United States has told us that the Constitution is the #1 rule. That's the rule we're going to go by. If the Constitution says one thing and the rules of procedure say something else, the rules of procedure have to be altered, changed, or abolished, one or the other. One of those three items. Look over here in our state constitution, page 3, and it'll say down here, guarantees in a criminal action and due process of law. In all criminal prosecutions, the party accused shall have the right to a speedy and public trial, to have the process of the court to compel the attendance of witnesses in his behalf, and to appear and defend in person with counsel. All right, and so I'm sitting here, I'm listening to this, you know. Now, I bring up the subject of the grand jury. Well, Your Honor, I'd like to bring to the court's attention, and I'd like to demand at this time that the court take judicial notice of Article 1, Section 8 of the Constitution of the State of Idaho as it relates to this citizen's rights and this defendant's right to due process of law and equal protection of the law under the Constitution. It says here, Your Honor, that prosecutions only by indictment or information. I'm sitting here, Your Honor, let the record show, with an information before me. It says, no person shall be held to answer for any felony or criminal offense of any grade unless on presentment of indictment of a grand jury or on information of a public prosecutor. This lady over here, whom I've referred to in the past as a flat-chested twit, is not a public prosecutor. And here, Your Honor, is the Constitution of the state of Idaho that says plainly that only on an indictment, only by an indictment of a grand jury in an offense of any grade. So here we find ourselves, Your Honor, with a prosecuting attorney, not a public prosecutor. I would contend, Your Honor, that a felony of any grade is an infamous crime. And I brought up the Macon case, and when we got the Macon case into the record, I'm telling you, when I got through, he said, well, Mr. Gordon, let me assure you that the information is the mode of prosecution in the state of Idaho, and all of your rights are being protected. Why, look here at the Constitution, Mr. Gordon, as we guarantees in criminal actions, and Mr. Gordon, we are guaranteeing you due process of law, wherein it says, you see here, Mr. Gordon, in all criminal prosecutions, sir, the party accused, I mean, these judges wax eloquent and get real pompous, you know, about this time. You've just caught them with their arm in the cookie jar, you know, up to their elbow, and now he's got to do something to get your mind off of the law. So what's he do? He reads over here, Section 13. The party accused shall have the right to a speedy and public trial, and Mr. Gordon, I'm going to see to it that you have a speedy and public trial pursuant to all of your rights. This guy preached me a sermon for 5 minutes about due process of law. and equal protection of the law, and a speedy trial, and a public trial. But damn it, that wasn't the issue. The issue was the grand jury. Did you catch that? They'll do that to you every time you open your mouth and hit a raw nerve. They change the subject on you. And the average layman is standing there in court, and if that doesn't work, changing the subject, then they'll intimidate you. They'll say, Mr. Gordon, there's a little room upstairs for people like you who obstruct and delay justice and try to disrupt the courts. And if it's necessary, Mr. Gordon, I'll have the marshals escort you out of here. And I'll appoint the public prosecutor, the public defender, might as well be the public persecutor. See, you've got to be prepared for that. So don't come uncorked, don't come unglued. Just sit there patiently, and I did this, and I listened to this judge for about 5 minutes. And I mean, he just came down on me something like you can't believe. I hadn't seen it myself the entire time I've been in court. That information and that public prosecutor versus prosecuting attorney and that grand jury is such a raw nerve in the judicial system of the state of Idaho that judge wet his pants right there on the bench, and I'm not kidding you a bit. He knows he's breaking the law. He knows for years. He's been sending people to the penitentiary, and that he's been violating people's rights, and he knows that those people that he's been sending there have been sent there in violation of their constitutional rights. And the only thing that saves him is they didn't demand their rights timely. They didn't object. They didn't bring the issue out and say, Judge, you got your arm in the cookie jar. I caught you. Now I'm demanding my grand jury. You see how important that rule is? The rules of the game are the whole game as far as I'm concerned. That's why you've got to know and understand these rules of the game.